You are PIL expert. This much we have understood. But the thing is, how you are concerned about it. This is what we want to know.
As a public person, I am concerned about. I came to know about this matter from the TVCC report, my lord, which is before already made by the BBMP, where the TVCC, that's a Technical Vigilance Committee of the Commissioner, has decided, given a report to the Commissioner, that there is a large-scale corruption. Only in respect of one ward, my lord, the loss of per year is 61 lakhs for the BBMP. I pointed out 3 wards, my lord, that ward number 13 and 14 and 71. In these 3 wards, I have information that there is large-scale corruption, which is being brought to the notice of the Superintendent of Police Anti-Corruption Bureau, Bangalore, but they have not taken any action, my lord. And I'm basing on my arguments on the TVCC report.
Your prayer is to issue retender in respect of BBMP ward number 13, 14 and 71 in respect of solid waste management.
But that is only because that is not the main prayer. My prayer number 2 may kindly be seen. To take initiate action. Against those erring officials have caused pecuniary loss to the BBMP, my lord.
What is your case? That the tender which has been allotted with respect to ward number 13, 14 and 71. That has been done at very low rate. At very low rate.
My lord, it is not been granted to the lower rate. It is given to the L2 bidder. L2 bidder, which is cost about annually about 61 lakhs in one ward itself, to the loss for the BBM. So that costs a very heavy amount to the public sector.
That means this is a proxy petition on behalf of L1.
No, my lord, I am no way concerned with the L1. I have only pointed out the report of the TVCC, where the TVCC says so, which I
whether the tender has been finalized.
Well, tender is actually granted.
Granted.
Yes.
Finalized, agreement entered into. Agreement has been done, work order has been issued.
Well, I am not having the full information regarding the agreement, whether the agreement was given or not. But the tender has been finalized and given in favor of L2, which is...
What material do you have to say that it is causing loss to the BBMP?
Well, it's a report of the TVCC. Your Lordship, kindly see page 77. It's a report of the TVCC, the translated version which I have produced. The very from the first line itself. The amount quoted by L1 bidder for 1 year period is 2 crores.
Where you are? 77, page 77, yes.
Page 77, Lord. Very from the start itself. The amount quoted by L1 bidder for 1 year period is 2 crores 64 lakhs 97,000.
Where are you reading?
The beginning, Lord. First line.
L1 bidder of Ward 71 and conveyed information about
188, and the same would have resulted in financial savings on the part of the Palike. But instead of taking any such action, the executive engineer solid waste management has given work.
You are reading somewhere else, Mr. Our page 77 does not contain this.
That's English translation. Starting from page 60, the translated copy of annexure E I have produced.
It starts from 59, page number 59. Translated copy of annexure E.
Page early. There is some mistakes I do concede that the pagination process. It's maybe page 76, my lord, if it's 1 page early. Like, starting from the beginning, if you watch before paragraph 11 of the report, the English translation.
Yes, read.
The amount quoted by L1 bidder for 1 year period 2 crores 64 lakhs 97,188, and same would have resulted in financial savings on the part of Palike. But instead of taking any such action, the executive engineer solid waste management has given work order to L2 bidder for a period of 1 year at rupees 3 crores 26 lakhs 13,216, which causes financial loss to Palike to the tune of 61 lakhs 16,028 per year. This is a finding of the executive engineer of the TVCC. And further, my lord, page.
What is your What is your source of procuring this document?
Lord, this is by way of, I have received it from through information, right to information act. I have reached in the very first itself. Beginning from
Which paragraph you have said?
To the same person it is being granted.
Which paragraph you have said that you have procured this document to right to information?
Lord, page 60 in my pages, your lordships have found it in page 59.
59. Okay.
They only have given this document to PDMP. Even further, my lord, after paragraph 11 also reiterates the same thing. It's a report of the executive engineer TVCC, my lord. Technical Vigilance Committee of the Commission. And in all these three wards, my lord, the TVCC has found that there is huge financial loss to the
What about where is the, with respect to other wards?
My lord, it's a total report is regarding all three wards, my lord, all three complaints. My lord, paragraph 11 onwards, your lordship will see in page 76 of your lordship. By bringing all the facts of for your perusal, though the tender for Ward 13, 14 and 71 related to solid waste management is exceeding 2 crores, the executive engineer has not conducted pre-bid meeting with the prospective bidder, thus violated orders of Government of Karnataka and the executive engineer solid waste management, evaluated the technical bid by calculating bid capacity based on turnover of the contractor even in the absence of work on hand list pertaining to bidder of Ward number 13. Further, it is not pertinent that bidder in Ward number 14 and 71 had uploaded financial bid and same has not been verified by the executive engineer solid waste management, and he ought to have contacted.
What is the date of this report? TVCC?
Date 24/8/21. It is in page 41 in my 24/8/2021. Other version is available.
Who is respondent number 6 and 7?
They are the bidders who have been granted in Ward number 13, 14 and 71. They are the successful bidders who have secured this.
So you were after them since beginning.
No, well, there is.
Yes.
It's not.
You moved the impleadment application in the petition which they had filed. You moved the impleadment application in the petition which they had filed.
Yes, ma'am. It was
So that
not
is what-
decided. It was
That
not
is
decided.
why we are saying that you were after them since beginning.
But my application was not allowed or rejected because when I filed the impleading application itself, they withdrawn the writ petition. Therefore, the writ petition has not come into a logical conclusion.
Who appear for BBMP?
Not served. First time it is coming up. First time it is coming up before the court. Notice is not ordered. It was not the complaint before the BBMP. One Federation Lords, page 61 of this CVC report says that Narayan, who is a complaint of the Federation of Workers, at his complaint, at his instance, all these exercise has been carried out. at the notings at the end, it reveals that even there is a variation in the financial bids. In the public interest, we have decided, because once it is cancelled, there will be piling up solid waste. For that reason, they have decided to go ahead with the L2 also. That reasoning has been assigned and work order has been issued. Subsequently, he gives a representation, Annexure D, page 28. Even he says, on behalf of Krishna Gowda, who is
Call Srinidhi.
Yes.
Call Srinidhi. We'll take
Please.
up again.
Please.
We're passing it over. Let him come.
Please. Please. Earlier.
Awesome.
Number 2, Sanjay.
Respondents. This is an appeal under section 37 against the dismissal of the application filed under section 34 of the Arbitration Conciliation Act. It was a claimant before the arbitral tribunal. The genesis of the dispute is that the tender was invited for the purpose of collection and disposal of the solid waste. In the event, the transportation of the solid waste had to exceed a particular.
Your 34 has been rejected.
34 has been rejected, That's my only ground which was raised before section 34 was this. The arbitrator rewrites the contract. The contract provides how the verification of the work has to be done, who has to certify, how the invoice has to be raised, how the payments has to be made, how there can be a reassessment of the payments which would be made, and thereafterwards, if there is any deduction to be made, that was permitted to be made within the next 30 days. But arbitrator says that to prove that you have travelled a distance beyond, you are required to examine the villages of that place. You are required to at least give me some logs on the basis of which I could have come to a conclusion. But the contract specifically says that the certification has to be done by the concerned authorities. And there is a 3-tier system in order of verification. There is a committee which is constituted. There is a certification which takes place. Even at the time of invoicing, there is a further certification of the works conducted. This is a case where the payments were already made upon all the certifications. After a lapse of 2 years, they started deducting from my next bills. The arbitrator gives only one reason. That even if it is a case of rewriting the contract by the arbitrator in the manner in which this has been appreciated, that does not come within the purview of section 34 for interference. That is contrary to the view which has been expressed by the Supreme Court in Sangyong as well as associated, where they have clearly taken a view. The contract, even for that matter, the court.
Where you have taken this ground before under 34?
If your watchers were to see, there is a very extensive arguments which has been canvassed before the learned commercial court. At para 22 and onwards. Para 22 and 22A is the answer. This entire contention is raised about the facts which I have now narrated before your WhatsApps. The only contention is it is not permissible for the arbitrator.
You are referring to para 22 and then come to para 22.
22A minutes. Can I read the para 22 minutes?
Give the page number.
It's page number 39.
Why you people are so much in hurry that before we open the paper page, you finish your with the argument.
Page number, in page number 39, paragraph number 22 of the orders passed.
A.
Please, minutes.
Yes, kindly read.
The 22 minutes, that's the contention which has been raised before the arbitrator, and 22A is its consideration by the commercial court. Internal page 4 of the orders. The first ground is that the claimant petition had raised invoices bills by indicating the total mileage covered by each one of the vehicles on daily basis. And these invoices were raised every month for the years 2006-07. And these invoices had been cleared in as much as there was a monitoring committee which verified the purpose of the claimants in accordance with the terms of the contract and the subsequent work orders issued. That is the physical garbage which matters, And it is a specific case of the climate petitioner that the physical garbage, which is a municipal solid waste, was transported beyond 50 kilometers, and the additional mileage gathered was charged at 10 rupees in the contract. That there was no dispute with regard to the fact that there was no other terms which was connected other than what was existing for the period 2007 to 2010. That even the work orders issued in the initial stages clearly indicated that pending finalization of the tender, work orders were being issued as per the original contract terms and conditions. That the question is as to from where the municipal solid waste was lifted and where it was dumped. That in order to establish these facts, PW1 examined himself, and PW2 being an employee was also examined to indicate that it was in respect of certain villages where there was a mutual understanding between the petitioner respondent and the villages that the dumping of the municipal solid waste was facilitated, and that is in this connection had been denied. The best course open to BBMP was to state where else it was dumped, because it was handling the dump in mammoth quantities as the generation in respect of package 19 on a monthly basis was in excess of 3,000 tons per month. That is not the case of the BPMP, that the municipal solid waste has not been lifted or shifted or transported, but the dispute is being raised to the place where the petition claims that the same has been dumped. That the physical verification has already been carried out by the BPMP is the specific case of the petition, and this fact has not been disputed, and that it is not the case of the BPMP that the solid waste has been dumped at any other place within 50 kilometers, that in an adversarial system, more particularly before the arbitrator, the material brought before the court has to be addressed to find out as to whether the version is more probable and acceptable. That if the petition is specifically shown in the invoices raised from point A to point B, the distance is in excess of 50 kilometers and has clearly indicated the place where the garbage is dumped, the best course open to BBMP was to physically and report to the arbitrator which then the arbitrator did not do, and on the contrary they did not take a contention. It is not that it was not dumped at point B and at some other point which was within 50 kilometers and it was not their contention. That is the physical garbage, and every month 3,000 tons of the garbage is being dumped at the place where the petitioner has indicated that whether the GPS system was maintained or not would not have been looked into, as no document was produced by the respondent to indicate that they had mandated the adopting of GPS into each of the vehicles for the purpose of claiming lead charges. That on the contrary, as per clause 6.3 of the contract, there is a monitoring committee to be constituted to ensure the compliance with the terms and conditions of the contract, which included the verification and the transportation of the garbage from 5A to 5B, and even the otherwise during the issuance of the work orders, the practice had been that the medical health officer would physically verify the dumping sites, and thereafterwards the bills had been cleared at the earlier instances. That when this was the situation, the circumstances which prevailed, if any other system had to be adopted, there should have been either a contract, but on the contrary, either by means of issuing a guideline, circular communications, or by means of any other modes or communications locking the system of inspection or verification. That only document produced by the respondent was the map of the village where garbage was supposed to have been dumped. The only letter and the circular that the report of BMPF which was relied upon by the respondent was wholly irrelevant document, in as much as this report of BMPF, which resulted in initiation of several proceedings, was quashed by the High Court, and the writ petition was produced at Exhibit P35. That the fact that these proceedings were quashed was also brought to the notice of the arbitrator. Evidence of PW1 and 2 remained unchallenged, and when the respondent did not take specific defense that it was not at point B, some other point which was a dumping of municipal solid waste, which is 3,000 metric tons per month, and these charges being claimed from 2006 to 2012 upwards. The bills raised itself clearly indicated it was almost 2 lakh metric tons of garbage which had been dumped during the course of this period. That physical verification mechanism which was required to be undertaken by BBMP, having not been undertaken, would not be a ground to refute the lead charges sustained. That the evidence of PW2, the evidence of
now how you say that it amounts to changing the terms of the contract?
the contract says, I just extracted the terms of the contract.
No, from this paragraph, how you say that the lower court has rewritten the contract?
I just explain it this way. The raising of the invoice was provided, which was to be certified by the monitoring committee which was constituted.
The in the proceedings under 34.
Section
The
34.
court is not supposed to act like an appellate court.
Certainly not. It is not at all an appellate court. Now, I am only
They are
making
summary
out a point.
proceedings. The summary proceedings. The evidence cannot be reappreciated by in the proceedings under 34.
I am not requesting that the evidence has to be reappreciated. Certainly
Yes.
not. Now, associated case is clearly.
There is very limited scope. There is very limited scope under 34.
Lord's limited scope does not mean that the arbitrator, even the court even refuses to look into the contentions which has been raised, saying that there is an embargo on me under section 34. Therefore, I will not.
Kindly show the blatant illegality. Show the blatant illegality committed under 34. Only then interference.
Lords, kindly have the look at the judgments, Lords, which I have produced. Only one paragraph, Lords, I wanted to read for your Lords.
Which judgment? First you show from this judgment which is under challenge.
Para 22A, Lords. Now having read this,
22A does not say anything.
Lords, para 22A.
Can you read?
Para 21A, Lords, at page number 43.
21A.
Please, Lords. Sorry,
Now from 22A to you have shifted to 21A.
I am sorry, Lords, I stand corrected. The consideration of para 21, which I now read to your Lordships, is at 21A. Para 40, page 43.
21. There is no 21A.
Lords, this is Commercial Appeal 106 of 2022.
105. It is
My apologies.
105 is the first case.
First case. Sorry. This will not, it will be para 22A. Sorry.
22A.
22A, it's not at page 40.
Yes.
In fact, the ground is in the nature and tenor of an appeal. Position of law is well settled that the court, while exercising powers in the section 34 of the Act, does not sit in a court of appeal, and the nature of proceedings in the section 34.
This is what we are telling you. Same thing we are telling you.
Now the limited scope with which an assessment has to be made of the contentions is what I wanted to bring to your Lordships with reference to associated case. I mean, just take your Lordships to one paragraph, Lords, in associated case.
First establish from your case, then only you can rely on any judgment.
The reason why I am making a mention is this. The tenor with which there has been an appreciation of my section 34 itself is fallacious in the sense that the requirement is to find out if the contract provides for the steps A, B, C, D, E to have to be taken place. Those steps having been taken and the invoices are already clear, can the arbitrator say, I want to take recourse to another mode by virtue of which you are required to
show from the record that the arbitrator has said so.
Lords, the arbitrator, Lords, kindly take the arbitral award.
Neither you have raised this issue before the in the proceeding 34.
See, before the arbitrator, Lords, now there was virtually no defense. I have already read paragraph number 22.
22 does not say anything about this.
I am only speaking about the defense which was raised by the BBFP, but there was virtually no defense. As such, there was no defense. But the arbitrator says, while passing the award, that the best course which was open for the claimants to have done was to go and examine the villages where this has been dumped. You had to require the logbooks and
forget about the defense which BBMP has taken. What is your case?
My case is very simple, my lords. I said my invoices were raised. The verification in terms of the contract has taken place. Invoices are already realized. Then, now they want it. Invoices are already realized. This is a case where invoices were already realized. But subsequently, after a period of 1 year or so, on the basis of a report by the Bangalore Metropolitan Task Force, they said, we are going to deduct whatever has been paid to you under the invoices as lead charges. That is in excess of 50 kilometers, 10 rupees per kilometer. We are going to deduct, and they deducted it from the bills. This is where the dispute started. That BMTF report under criminal proceedings stood quashed by this honorable court, saying that there was no jurisdiction and it was completely fallacious. Ultimately, those proceedings. But the genesis for making the deductions was that BMPF report, which was also placed before the arbitrator, saying that those proceedings are already quashed. Now the question is, contract says, you present the invoice, you present the certification, and we will clear the invoice. This has already taken place. Now, if you want to justify the subsequent withdrawal of this entire invoicing amount, there should be a defense which has been which should be raised by you. There is no defense. They only say that BMPF had given a report, therefore we have made deductions. This is their defense. But arbitrator Minos for the first time says, which is not their defense. The arbitrator actually makes out a defense for them, saying that while you were leading the evidence, it was required of you, you should have examined some drivers, you should have examined some villagers, on the basis of which I could have come to a conclusion that you are dumped at this place. This is something which is not forthcoming in the contract, not forthcoming in the defense. This is an introduction by the arbitrator.
Sorry.
Page 10, just draw your attention to one paragraph notes of one judgment. Suppose notes ultimately notes.
This is an admitted position. There was no dispute with regard to the fact that there were no other terms which was connected other than what was existing for the period 2007 and 10. The second thing is that physical verification had already been carried out. This you cannot dispute.
Kindly have a look at.
By the BBM and specific case, and this fact has not been disputed.
Kindly have a
So
look at
these are the findings on now how what is wrong in this?
Let's kindly have a look at the award. Kindly have a look at the award for a moment. Page number 103, internal page 32.
Page?
Page 103, internal page 32 of the arbitration award.
103.
Arbitral awards. Yes. 103, internal page that after this comes after.
Yes.
But I just wanted to indicate where the mischief has occurred in the arbitration award itself. You know, when the arbitrator specifically speaks about the escalation charges, which was permitted, kindly take note, page number 103 and page number internal page 32, about 4 lines from the 5 lines from the top. The sentence starts as, it is not as though that for the first time such a claim is made before this tribunal.
Yes.
Really escalation charges. I'm sorry.
Yes. It is not.
Really, the escalation charges had been claimed by the claimant in the monthly bill submitted, and if the same had been granted to the claimant by the respondent, monthly bill so passed would indicate the same. The respondent, that is the BBMP, is the custodian of all the monthly bills submitted by the claimant, and if really the claim made by the claimant is false or duplicity in nature, nothing would have come in the way of the respondent to produce the bill so submitted by the claimant. Even on this count, also the claim made by the claimant for escalation charges is justified. Accordingly, the claim is rejected. Note the same procedure is followed even insofar as the invoices pertaining to the lead charges. Now, kindly come notes to the findings which has been recorded at page number 99.
Now, what do you want to show from
Note,
this?
what I want to show is the arbitrator adopts a dual approach. When it comes to the question of the invoice consists of 3 parts: the actual charges, lead charges, escalation charges. The actual charges is to the extent of 50 kilometers, which is as per the tender rates. If I travel 1 kilometer more, I will be given 10 rupees extra. That gets added up into the invoices. Then there is a permitted escalation which is permitted, which also gets added into the invoices. So there are 3 components in the invoice. When it comes to the component of the lead charges, the arbitrator says you should have produced evidence to show you have actually dumped at this place, without which you are not entitled to claim for lead charges. This is the finding which has been recorded by the arbitrator. But the fact situation before the arbitrator was that the invoices had already been cleared upon a certification in terms of the contract, and corporation never disputed the correctness of of the reports on the basis of which the invoices were already cleared. They only said that since there is a report by the BMPF, therefore we wanted to make deductions of the lead charges.
So you don't want to prove that.
Lords, we have proved it. That's the reason why I said, Lords. Now I can prove it in terms of the contract. If I am expected to prove beyond the terms of the contract,
What do you say?
My lord, whatever the learned friend has read in para number 32, it is the assertion of the claimant itself, my lord. What has happened in this case, they have not at all proved the lead charges or escalation charges. Equal opportunity has been given before the arbitrator. And
He
there is
says that that is the admitted position.
yes,
This is what his argument is. That is the admitted position.
they have not proved before the arbitrator, and there is no patent illegality alleged before this one. And the scope of the arbitral challenging the arbitral award is very limited. Madam. There is no patent illegality award. Equal opportunity has been given before the arbitrator.
If the award has been given contrary to the evidence, then
They have not proved before the arbitrator.
this is what his argument is. This is what his argument is. The award has been given contrary to the evidence.
I'll file the detailed objection, madam. I'm a caveat in this case.
Given
I'll file my objection.
okay.
Matters have been decided. Similar matters have been decided. 24. Similar matters were there. 24.
Some similar matter have been decided. Who has given this? You have given.
Committee appeal number 100 of 2020. Sorry, 96 of
25th
2020.
was decided.
Same.
Eight other cases are dismissed on the same this one.
Show it to him.
Those- Same instructing counsel on record.
You're instructing counsel.
All similar grounds and all similar contention.
Your assisting counsel is not fair.
I'll leave it at that. I don't want to say anything further.
He should have at least assisted you properly. He should have informed you.
I have to.
The same counsel. Huh?
I'll write, sir. I'll follow this and write everything. Sir.
There's something very, very
In the
sorry.
peculiar circumstances of the present case,
No,
notes,
this is
which I am now before your lordships, I am in a position to demonstrate, notes, that whatever has been done by the
We
arbitrator.
cannot take a contrary view than this. Mister,
I leave it at that, notes. I don't want to say anything. further.
you leave it at there, we should impose cost. We should
I
impose
apologize,
cost.
I sincerely apologize on behalf of my instructing counsel. Lordships may, I was not aware of this.
Oh, refer his matter to the bar council. This is not fair on the part of the council. Not at all. Why we should not refer his matter to the bar council to be so much of unfair to the court? When a similar matter has been dismissed by this court, are we supposed to remember everything?
Certainly not. Notes. It is
Then,
our responsibility to
It
ensure
was your responsibility to have informed the court.
I fully bow down to what your lordships have indicated. I fully bow down to what your lordships.
He is the same counsel.
Sanjay ji.
I do not remember, I do not recognize anyone, but it does not mean that you will take advantage of that. Yes, mister? We'll issue notice to you. Issue notice to him to explain. No, we will take action against you now. We'll not leave you like this.
May just make this. May make this.
Issue notice to him,
May make this.
calling upon him to explain his submission. Issue notice to so and so to explain his conduct as to why he has not informed the court that under similar facts and circumstances, the case number such and such has been dismissed on merit. And why he had not.
Sorry.
No, we will
Because
not allow him to practice.
At the
No.
first instance, I owe a duty to the court, notes, but
Will not allow him to practice anymore. He is restrained from practicing anymore. You will understand, mister. This is court of the Chief Justice. When you can do it with here, what you will be doing in other courts? What you would be doing in other courts? When you can do it here with the Chief Justice, then look at your conduct. No, sorry. No, we are not going to leave you like this. He is restrained from practicing anymore.
notes,
We will take out your gown. Remove your gown.
I make a fervent request to your lordships. Your lordships may kindly.
Look at it.
I
I had never seen it in my entire career. A lawyer like this.
I will take personal
I have also put in more than 35 years.
I am making a submission, notes. I take personal advise him suitably, notes. Lordships may leave it on me. I will advise him suitably. Your lordships may kindly take a lenient view. I will ensure that he will not repeat this in future. I will ensure that. Lordships may.
Mister, we are not saying anything against you.
No, I.
We are not saying deliberately, we are not saying anything against you.
Representing the.
Yes, you are senior advocate. You also owe some responsibility towards the court.
I have a, that's the
Yes.
reason why I am making a submission, notes, with all the responsibilities.
I never thought that I will have to face such a situation here in Karnataka.
Sorry, that's the
This
reason
is
why
High
I make
Court.
a fervent request, notes, that
Look at it.
I
Call the president of the Bar Association. Call the president of the Bar Association. Immediately we are going to take action against this person. Will not allow you to practice anymore, mister. You don't know me. You will understand what you have done. Call the president. I will show him these are the members of the Bar Association who are practicing here in the High Court. Look at it. And when it has been dismissed?
Friday.
Few days back.
Last Fridays.
He even cannot forget that his petition has been dismissed. On 25th. All these petitions are same.
Same.
It's a civil liability petitions in this country, proposals to say 105, 106,
All same, sir. All contractors. Same. Escalation lead.
113.
And all 6 grounds with section.
What do you have written?
Dismissed on merit.
Why his matter shall not be referred to the Bar Council for taking appropriate disciplinary proceedings. No, you have done it deliberately, mister. Now you will understand. Yes. Now we remember, you were not ready to argue the matter, and we had asked you to argue the matter on merit, and thereafter we had passed this order. Wearing mask, therefore I could not recognize you. Now you have removed the mask, now I recognize you. That day you were not wearing mask. In my entire career, I have not faced this situation ever. This is for the first time. A lawyer can be so dishonest. Because what we believe the lawyers in the face of it. We don't even turn the pages to verify. What is your name, Mr.? Sanjay?
Ravi Shankar and DR Ravi Shankar, recent batch.
What of tomorrow? You file your affidavit. Let the order be remain. Issue notice to him. File your affidavit tomorrow. We'll have the matter tomorrow.
My apologies to you also.
I appear for the KV terminal.
A pre-filing copy has been served on the caveator. Whereas this is an order, this is an appeal challenging an order under section 9 of the Arbitration and Conciliation Act. Let us submit that in the time leading up to the filing of this appeal, the parties were discussing a settlement mutually. I am given to understand that those terms have been settled now and have been finalized. In light of that, is there a request for a date to be set, and I can have the parties present before your lordships and a joint memo filed with the terms of the settlement. Counsel for the respondent is also present on these.
Interim measure. Interim
Section 9
amendment 9 has been doesn't come within that, the other judgment.
Manoj, during the pendency of this appeal, I'll just make one submission, not on the merits, Manoj. The parties have been mutually discussing a settlement. I'm now instructed that the terms of those settlements have been finalized. We'd like to place the terms of the settlement on record before your courts, before this honorable court as well, by way of a joint memo.
Then why you have challenged it? Why, what for you have challenged it?
What?
Why you are challenging the order?
We challenged it, Manoj, because a mandatory injunction has been granted by the trial court in a Section 9 application, whereby I am now being forced to supply power to the respondent company.
Yes.
Manoj, that by virtue of good faith, Manoj, we've continued the supply of that power given the amicable relationship between the parties. We've challenged it because the order continues, Manoj, and the arbitration has not yet commenced.
I think after the appeal was filed, they are trying to resolve it.
Manoj, we've taken the stance that the reliefs themselves were untenable, being of a mandatory nature. That's one ground that we've taken, Manoj. We've also gone into the issues of whether the court in a Section 9 arbitration should have granted a relief of mandatory injunction, given that many of the issues were such that should have been decided in trial, Manoj.
Why?
Manoj, because it is a question of termination of contract, Manoj. I have terminated in a determinable contract.
Okay.
These are issues of trial, Manoj, that we would like the arbitration itself to go into.
They want to settle it.
They will not grant any order. We only ask
No interest.
to serve them. Can you serve respondent outside court?
Manoj, we've already served a copy on them. They were on caveat, Manoj. I've served a pre-filing copy on them. They're present on PC today.
Where's
Appear for the on behalf of the caveat or advocate, my lord.
yes.
Parties, my instructions are that the parties have settled the dispute. The terms have been agreed upon. Therefore, they are requesting for 8th or after 15th. That is what my instruction, that there is a settlement which has taken place. Because we had filed a CMP, the notice was also issued. Subsequently, they had filed this.
Learned counsel for the appellant as well as learned counsel for caveat or respondent number 1 seek time to report amicable settlement. Relist on 17/3/2022.
Grateful.
Respondent process.
Serial number 8.
Petitioner apparently has filed a memo for retirement.
My lord, I'm appearing on behalf of petitioner, my lord. We have
Judgment is filed with the petitioner.
Petitioner is no more, it's expired.
Is expired. 17/4/2021. Petitioner sole petitioner is expired, and the son is before this honorable court. So here, son is before this, and he wants to file wakalat. He has to get the wakalat because there are 5 survivors from legal age. So they want to file a wakalat and necessary application.
Lordship, my respectful submission.
This petition is then abated.
Yes, Lordship, this is pertaining to a license. Now, whether an LR can come on record pertaining to a license, mining license.
And you have not moved any application within time.
Yes.
No. After more particular third respondents issue mineral dispatch permit to the petitioner. Now petitioner is no more. Consider representation of petitioner for lifting transportation of iron ore. This relief cannot be granted to him.
Yes.
Lord, moreover, this petition was filed in the year 2017, claiming the relief of the year 2007 after lapse of 10 years.
And the
But
money,
he is seeking to.
That we will not go and do that. Take down. You appear for?
I appear for the sixth respondent. I'm an impleading applicant. By virtue of my PIL, the mining had stopped.
Heard. The writ petition has been filed seeking following relief. What is your name?
Rajeshwar Singh.
Rajeshwar Singh.
Rajeshwar Singh.
Rajeshwar Singh.
Son of the petitioner.
No. What is your name?
My name is Venkatesh Prabhu.
You are Petitioner Counsel.
Still we have to receive Wakala because he has asked for my assistance, so I come before this.
They're still not on record.
Still I am not in record. Please.
Advocate on record has filed a written.
Memo, yes.
The advocate of
My lord, we have filed a memo for retirement, my lord.
same is accepted. First off, what is his name? Rajeshwar Singh. Rajeshwar Singh, son of petitioner Dr. Yogendra Nath Singh, is before the court. It is informed by him. He is identified by क्या नाम है आपको? What is it?
Venkatesh Babu.
Huh?
Venkatesh Babu. Venkatesh Babu.
Venkatesh Babu, advocate. It is informed by him that the sole petitioner, Dr. Yogendra Nath Singh, has died on
Lord, on 17/4/2021.
2021. Full stop. Rajeshwar Singh wants to be impleaded in place of the sole petitioner. Full stop. The learned counsel for the sixth respondent as well as learned AGA appearing for first to fifth respondent submits that the writ petition was filed seeking a direction for issuance of mineral dispatch permit in favor of the petitioner. The alternative relief prayed was to consider the representation dated 1/8/2010 made by the petitioner for lifting of oblique transportation of iron ore lying in the survey number 116, 135 and 207, measuring 18 acres, situated at Marathi village, Sagara Taluk, Shimoga district. Full stop. It is submitted that the writ petition was filed in the year 2017 relating to the permit was granted in favor of the petitioner earlier.
It was not renewed. They had sought a renewal of the license which the government did not permit.
What you've written? Relating to the renewal of permit.
And one more writ petition was filed by the petitioner.
Pertaining to the which had expired in the year 2007. Full stop.
Lord, one more.
Considering the facts and circumstances of this case, we are of the considered view that once the petitioner has died, the relief claimed by the petitioner cannot be granted, and writ petition stand awaited. The petitioner, in the given facts and circumstances, cannot be substituted by his legal heirs.
One more aspect.
One more, in this one more writ petition was filed, in that action may be permitted to, because one more writ petition to take away the, actually this is not regarding the renewal of the license, my lord. This is regarding the, right, petition is regarding the taking of the material from the stored place, my lord. There are 1,10,000 material is available.
That is
One
also
lakh
an
eighty-
offshoot. It's also
See,
an offshoot of the same license.
That also cannot be granted in his favor.
Grateful, Lord.
Number 9. Perfect.
Section 9 petition was dismissed.
The first interim order was granted, then notice was not ordered. So
Notice is not yet awaited, that's what casted.
What is the office report say? Service?
Still awaited.
Service has been done or not?
It is dispatched on 23.
You cannot see it from the cause list. You will have to see it from the office report. Okay, cause list, so we are also seeing that no one has put in appearance.
Notice has been issued on 23 to 22, my lord. And still service is awaited.
Office has to
Waiting
for.
waiting service. 23 to is issued, awaiting service.
As per office report, the service on respondent has not been effected as yet. Adjourned. Give a date after 2 weeks.
Interim order expected up to this date.
After 2 weeks, interim order finish and continue to next day.
31-3. Number 10.
Appeal for the applicant. As per the order of this honorable court, have corrected the nomenclature. The office wants an order from the court to give a fresh number. An order dated
converted into commercial appeal. Present appeal arises out of Commercial AS number 213 of 2018 under the Commercial Codes Act 2018, the present appeal is hereby converted into an appropriate commercial appeal. Full stop. Registry to carry out necessary corrections and post the matter before the appropriate bench having roster. Full stop. MFA disposed of for statistical purposes.
11.
same man.
Same order.
Like,
Number 12.
For the respondents in this matter.
The order under challenge is an order passed under Section 9 of the Arbitration and Conciliation Act. The appellant contemplated to take up a project running into multiple floors. The respondent claims that there is an agreement of sale executed in his favor in respect of one apartment of type A to be constructed on the 7th floor of the apartment complex. Order of injunction was granted till such time the arbitrator enters reference. But the arbitrator has been appointed, arbitrator has already entered reference, and the pleadings are also not put forth by the claimants, and it is now pending for my objections. Notwithstanding, though the interim order which has been passed in Section 9 is restricted only till the entering of reference, which eventuality has already occurred. I am making a statement that I will go ahead with the project and I will not alienate the C scheduled property, which is the apartment complex to which he claims an agreement till the disposal of the arbitration proceedings. Their apprehension was that I will not go ahead with the project. I am making a statement, I will do the same project. That statement, my lords, I had made it on the last hearing date, if your lords were to.
What we can do is, we can direct the reference to continue. But now the respondents have to dispose of this, but the respondents have in reserve liberty to them to file an application to arbitrator under section 17.
Yes.
What is agreed under the agreement of sale is not just suit schedule C property.
What he is
Along
saying.
with, that's what I am submitting. Along with suit schedule C property, the undivided share in the land also was agreed to be sold. That is in suit schedule B. Schedule B property. But what has actually happened is this. The apartment is supposed to be constructed in 7th floor. Now, Milord, I have produced along with the applications filed before this honorable court to indicate that, Milord, the building has not even started even at the ground floor level, even though, Milord, the sanction plan was given in 2013. Now, Milord, what has happened is after 17/12/2000, after the earlier order passed by this honorable court, the respondent number 1, so appellant, Milord, has executed a registered mortgage in respect of the entire suit schedule A property in favor of the proposed respondent with whom I want to implead by means of this impleading application by taking 2 crores 25 lakhs, which includes not only suit schedule Z apartment portion and also suit schedule B property, which is agreed to be sold. Now, 2000, let me complete. 2013 is the date on which the sanction plan has been obtained. In 2019, an agreement is executed in my favor, wherein it was agreed that by 30/6/2020, with a grace period of 6 months, the project will be completed. I have produced the photographs your lordship may kindly see along with the application. The status of the construction is like this. Before the court below, Milord, a category.
What do you want?
My only respectful submission is this, Milord. So far as the proposed respondent is concerned, he may have to be impleaded in the proceedings because if during the pendency of these arbitration proceedings, the appellant has gone to the extent of, mortgaging the entire property and he has created third-party interests. So in that background, I have filed the application for impleading. And I am also seeking for an interim order. Let him not further alienate the property.
He says that he gives an undertaking that let him be permitted to continue with the project. He will not alienate.
Milord, my only respectful submission.
I'm sorry, Milord, I just add one more sentence. I will also further undertake in the event of his final success in the arbitration proceedings.
That
But
is
just
also-
to record my undertaking that I will convey this property encumbrances in his favor. Let him not have any apprehension that in the event of me encumbering property, I am making a statement that I will not alienate the C schedule property. And if he finally wins in this arbitration proceeding, I will ensure that this property will be conveyed to him free from encumbrance. I'll file an affidavit to that effect before your lordships.
Already there is a third party creation of interest.
We'll impede him.
Yes, Milord. Your lordship may impede him.
We will impede him, but
Yes,
so far as he is concerned,
Yes,
let
Milord.
him be permitted to go ahead.
The comments.
Third party which for whom you have moved the application, and we will record his undertaking and your consent that you do not have any objection in case this is permitted to carry on the project, and he will not alienate the property and he will hand it over to you on that.
Free from encumbrances.
We'll dispose of, and now you go and get the arbitration proceedings decided. What for we'll keep this pending?
I understand. My only request is, my only aspect which I want to draw your lordship's kind attention is, before the court below, a categorical statement has been made by the appellant in the objections filed in section 9 proceedings, saying that they are not willing to complete the project.
Now he is saying that.
I file an affidavit of undertaking in that regard.
But they should also say within what time they are going to complete the project, because
This is what
my
we
apartment is in 7th floor.
We will record his statement. Let him start. With what time we will complete the process?
Lords, now I am bound by the, I am registered under RERA, Lords. Now the timelines will be stipulated by RERA. Whatever time is permitted by RERA, because I may say 3 years, but RERA is not very considerate between Lords.
2018, this registration has happened with RERA. We are in 2022, Miller. The construction, I have already put photographs, which clearly indicate,
It is
Miller,
at his risk. He is doing it.
Miller, your lordship may make
Right.
proposed respondent in the arbitration proceedings.
Allow kar do. Your application is here.
Yes, Miller.
Application is pending.
No, I have to file there, Miller, because this MFA was pending here. I filed the application here.
2 of 20.
That liberty can be reserved, Lords. He can seek to impede, and that application can be
Yes.
reserved by the Honorable.
Any objection?
Lords, impleading the application, Lords, I have absolutely no difficulty, but the only reason what I am submitting is this.
We will dispose of the matter itself. You carry out the impleadment during course of the day.
Because once the impleading takes place, if your Lordship has to again notify to defer the hearing of this matter.
No, we are not deferring it. We are just impleading him, making him a party in the proceeding, that is all. But we are not issuing any notice to him. We are not issuing any notice to him.
Very well, Lords. Very well.
Let him be a party.
And we can permit, I may be permitted to implead him in the arbitration proceedings also.
But
That is very important. Otherwise, Miller, it becomes.
I would rather suggest, Lords, that your Lordships may permit him to make an application before the arbitrator to implead him, and that arbitration arbitrator.
That would be better, in fact. That would be better instead of impleading him here. Let the matter be disposed of here. Without impleading him, we will give you liberty to implead him in the arbitration procedure.
Your Lordship.
Whatever applications, whatever claims that them for. Impute order dated 19/10/2020, passed in 8 of 2020 by the 9th Additional District and Sessions Judge, Bangalore Rural District, Bangalore, whereby the aforesaid application filed by the respondents under Section 9 of the Arbitration and Conciliation Act was allowed by the trial court, thereby granting temporary injunction in favor of the respondents against the appellant, restraining the appellants from alienating a scheduled property in favor of anybody, and also from changing the nature of development plans pertaining to a scheduled property till the arbitrator enters upon reference. Full stop. Next para. Heard learned senior counsel for the appellant and learned senior counsel for the respondents and peruse the material on record. Full stop. On 17/12/2021, this court passed the following interim order. Extract. Full stop. Learned senior counsel for the appellant and learned counsel for the respondent jointly submit that during the pendency of this appeal, the arbitral tribunal has entered upon reference and the matter is posted before the tribunal on
They are expected. What has happened is this, what has happened is this, they are expected to take notice.
All right.
They have not even taken notice.
has entered
We
upon
have taken notice.
All right, all right.
Not for time to file
We
the
will-
arbitration.
we'll-
All
we'll-
right.
2 weeks.
has entered upon reference and the matter is seized by the arbitral tribunal. Full stop. During the pendency of the present appeal, the respondents have filed 2 applications, IA 1 of 22 for temporary injunction against the appellants and IA 2 of 22 seeking impleadment of one Messrs. Aham Ventures LLP as an additional respondent to the present appeal. Full stop. Though several contentions have been urged by both sides, full stop. In the Munche, on instructions, learned senior counsel for the appellant submits that if the appellant would complete the construction and would not claim any equity in that regard, full stop. Learned senior counsel also submits that the appellants will not alienate the A schedule property. So, C schedule
Your
property.
Lordship may say B and C schedule property.
Not B
B
is
is
an
the
undivided
undivided
share of
share.
land.
If
If I want to develop the property, that's the reason why I made that statement also. If I have to raise finances, I cannot
What will
bifurcate
happen
this
is this.
asset.
B schedule is part of A schedule.
Interim
property.
order,
Yes,
interim
Mr.
order which is passed on 17/12
Yes, Mr.
is restricted to C schedule.
I understand, that was the statement made by him.
If you want to
My-
change it,
My only request is this.
if he agrees, we have no problem. But if that has to be modified,
Yes, Mr.
we'll have to hear and modify.
Your
Without
Lordship,
hearing, it has to be
but
only
what-
C
my
schedule.
only submission is in the agreement of sale in my favor.
So that's what, sir.
Yes,
If we
ma'am.
want to modify that interim order,
Yes, Mr.
we have to hear and modify.
But I would not, I would.
Otherwise-
Yes, Mr.
Otherwise, we'll have to stick to whatever is said in the earlier order.
That is only a statement made by my learned senior counsel. And it was
Sir,
not
there
really.
is a
on-
court order.
I understand, after recording his statement, that was the.
There is a court order.
In order to assure my learned friend, my lords, I am making a statement, I'll file an affidavit. In the event I were to commit a breach, that at the time when I am giving the property to him, in the event he wins the arbitration proceedings, lords, he can bring about contempt to me because I will file an affidavit of undertaking.
No, that's
I am
why
undertaking
that's
that.
why we thought instead of recording any undertaking here, this interim order we will continue.
Yes, ma'am.
Both of you can file any application under 17 or whatever before the tribunal.
Your Lordship may make it clear
We'll leave
also.
it at that. Right. Entu? ಬೇಡ ಬೇಡ ಅದು ಬೇಡ. Though several contentions have been urged by the appellant and the respondent in the present appeal and also the interlocutory applications filed in the present appeal, having regard to the fact that the dispute between the parties is seized by the arbitral tribunal, without expressing any opinion on the merits/demerits of the rival contentions, we deem it just and appropriate to dispose of this appeal by relegating the parties to get their dispute adjudicated/resolved before the arbitral tribunal. Full stop. Liberty is also reserved in favor of the parties to file appropriate interlocutory applications before the arbitral tribunal seeking appropriate reliefs, including applications under Section 17 of the Arbitration and Conciliation Act. Full stop. The arbitral tribunal shall consider and dispose of all the main matter as well as the pending as well as interlocutory applications to be filed by either of the parties without being influenced by the observations and findings recorded in the impugned order. Full stop. It is further directed that in the event either of the parties file interlocutory applications before the arbitral tribunal in the pending arbitration proceedings, and the same are considered and disposed of by the arbitral tribunal, the order dated 17/12/2021 passed by this court in the present appeal shall continue to remain in force. Full stop. The arbitral tribunal is directed to dispose of the applications and proceedings strictly as per the timelines of the Arbitration and Conciliation Act 1996.
The implement of the proposed respondent.
Hakkoli.
Your Lordship may kindly make it clear.
Including 17 ಅಂತ ಬರೆದ್ರಲ್ಲ 17 ಜೊತೆ as well as
Your Lordship may say that the proposed respondent should be implemented.
liberty.
Why, what I am submitting is this. It is a case
Right.
where in the pendency of the arbitration proceedings, they have.
All right.
Yes, sir.
It is further directed.
Wanted to indicate, that As a matter of fact, we wanted to cancel that mortgage. We wanted to have a proper.
Let him be impleaded.
Therefore, these are the facts which we will bring it before the.
No, he doesn't want an IA to be filed, opposed under detailed order.
Yes, Milord.
And it will lispendence. Therefore, we'll say that in view of the undisputed fact that the proposed respondent slash the proposed respondent who sought to be impleaded in IA number 2 of 2022 at the instance of the respondents herein claims to have is said to have acquired right in the subject.
No right.
Mortgage is said to be a proper and necessary party to the proceedings. Is said to be in view of devolution,
In view of the mortgage, Milord.
in view of a transaction
Of a
The
mortgage.
nature of mortgage.
in the nature of a mortgage said to have been entered into by him during the pendency of the arbitration proceedings, the tribunal is directed to implead the proposed applicant, the proposed respondent as an additional party to the arbitration proceedings and proceed further in the matter.
Much.
Right.
Great.
That's all, sir.
Pending applications.
Survey.
The arbitration award came to be confirmed under section 34 months. This matter, Manoj, I just had a word with my learned friend, Manoj. We may try and settle the matter, Manoj. Your worship may kindly grant 2 days. Monday we'll try and report settlement in the matter.
I prefer the second respondent.
This question, what we are requesting is waiver of reduction of
short explanation on his request, case urgent. Limited.
My lord says that rules are framed yesterday, my lord. I filed through e-filing, my lords. Physical copy I could not file. E-filing I have done, my lords. Rules yesterday, my lords. Rules are notified. In 2 days' time, my lords, we will gazette in e-gazette, my lords. Thereafter, my lords, 15 days, my lords, we have provided in the rules to file objections. E-filing I have done, my lords. Hard copy is with me, my lords. Today I file this. Rules. Amendment to my lords rule 71A, prescribing qualification for the my lords inspectors. They are notified yesterday. Delay, my lords.
Rules have not been notified.
Yes, my lords. It is notified yesterday, my lords. I have filed through e-filing, my lords. I have hard copy, my lords. Today I will file. And my lords, it will be gazetted, my lords, in 3 days' time. I have stated in my compliance report. It is notified yesterday. It will be gazetted in 3 days' time. My lords, 15 days' time is provided to file objections to these draft rules. Just may I kindly adjourn the matter by 4 weeks. I will come with my lords after the my lords objections rules I will place before the court. This compliance I will file in the registry. E-filing I have done here. Rules have been notified. Bear with me. It was notified. I could not file it.
Now, what is to be done now?
Now, my lords, rules have been notified. My lords has directed to place the notified rules. Yesterday it was notified. It was sent for gazetting, my lords. E-gazette will be done in 3 days' time. Thereafter, my lords, these are the draft rules. To the rules, my lords, prescribing qualification for the inspectors who will be, my lords, appointed by the council. Because once it is objections are considered, after 50 days, my lords, we will place the final rules before, my lords.
We have to, my lord.
We have complied with the direction dated, my lords, 14/2/22, my lords. My lords has directed the reason that the Honorable Minister could not, my lords, proceed the file. My lords has directed to place the file before the Honorable Chief Minister. Before that only, my lords, we have brought to the notice of the Honorable Concerned Minister. It is, my lords, approved now, my lords. It is notified yesterday, my lords. The order has been complied with.
After this, my lord, the State Council has to appoint, my lord, the inspectors under section 26A of the Act. That we will do after notification, after notifying these rules.
After the final rules, my lord, they will take
Because
steps.
qualification was they prescribed, it should have.
Why you want 6 weeks time?
No, but 15 days time to file objections to these draft rules. 15 days time. From 7th. Before 7th, we will gazette these notes. These are the notified rules, but it is not gazetted. 3 days time, e-gazetting will do it. From 7th, 15 days time is provided under the draft rules itself to file objections to these rules. Thereafter, we will issue the final, maybe 3 weeks, 3 to 4 weeks maximum.
Did AG?
But I'll file these compliance, it is there.
On the basis of instructions informed that draft rules have been notified and
on 2, 3.
Rules for qualification of pharmacy inspector would be gazetted within 3 days.
3 days.
Thereafter, 15 days time would be required to
call for the objections to these rules.
Call for the objections and finalize the rules.
Thereafter, once again, we will gazette.
As such, the matter may be postponed
Please.
for 3 weeks. Adjourned list after 3 weeks.
One submission, ma'am.
4th April.
One submission, ma'am. At 26, they have to take sanction, ma'am. The sanction has been given only for 11 months, ma'am. Sanction for the post has been given only for 11 months. Sanction for the post of inspector has been given for only for 11 months, ma'am. And also with lot of conditions.
That is in GO is there.
How it is possible to implement the law?
My lord, these rules, in the absence of these rules, temporary measures were taken. That once rules comes, it goes. Once rules comes, they will appoint the permanent inspectors. That problem will be solved. Once for all, problem will be solved. That was a temporary measure, so we have taken that. Now rules are notified.
Clause G is contrary. Clause G is contrary.
Counsel for the petition.
Supreme Court order.
Counsel for the petition.
Supreme Court order this time.
There is Supreme Court order. There are two aspects of the matter.
Where is that?
I'll pass. What I can download from the Indian Counsel. When this judgment, Watches were pleased to dispose of two of my petitions on 17/12/2021. That I have challenged the notification.
No, the earlier petition number 12027/2015.
Yes.
But it is not mentioned in this order.
No, that was a transfer petition which your lordship. This is the petition which was transferred to the Supreme Court from Delhi High Court. And while transferring the matter, my lord, I have a copy of that order also. I'll pass it on to you.
appears, my lord, the transfer petition number is 910-913 of 2016. The main petition is 12027 of 2015.
Where is that?
But I tried to download the same.
No,
but
from the website, we are unable to get the copy of the
petition.
it shows that it is disposed of.
This has gone to Supreme Court.
Yes.
Supreme Court, Honorable Supreme Court, while deciding the validity of the notifications issued, giving retrospective effect to the establishment of District Mineral Foundation, upheld the notification, but only stuck down to the extent that it allowed them to charge the District Mineral Fund contribution with effect from the date on which the law was promulgated. Now, my petition involves two aspects. One, I have challenged the notification demanding DMF contribution with effect from 12/1/2015. Now that stands resolved by the Honorable Supreme Court. I may not have any arguments to make. But there is another notification which was issued by the government under Section 9C of the amended MMDR Act. That is Mines and Mineral Development Regulation Act of 1956, with effect from the date on which the Act came into force. Two bodies were constituted. One is called District Mineral Foundation. Other one is National Mineral Exploration Trust under Section 9C of the Act. Now, the notification which establishes that doesn't give it a retrospective effect.
Where is that annexure?
That, yes, Lord, take your lordship. The notification establishing NMET is at page number 43, my lord. Annexure D3. Both in Hindi and in English.
Correct.
But before I make submissions on the merits of my contentions, my lords, the lordships on 17/12/2001 have disposed of two of my writ petitions, of course, where I was appearing earlier before my designation. Those two were disposed of on the submissions made by the Counsel for the State that it is covered by the judgment of this Honorable Supreme Court. But there, I had raised the question regarding the validity of the other notification whereby the central government had established NMET, but not with retrospective effect. However, my lord, that fact was not brought to your lordship's notice, and lordships were pleased to dispose it off in terms of the other judgment which the Supreme Court deals only with the District Mineral Foundation. That stands concluded. I may not have any grievance. But here, as far as this matter is concerned, my lord, I have challenged the demand made by the state government for contribution towards National Mineral Exploration Trust with retrospective effect. That is from 12/1/2015. That is not permissible. That is collected from me at the rate of 2% of my royalty.
Yes.
May I request for a week's time, Lord, because that will have a direct bearing on the judgment of the Supreme Court in civil writ petition 12027 of 2015, which your lordship was to direct the Council to produce the same. So I also tried to download the same from the website. I could not do.
All the matters which were transferred to the Supreme Court, my lord, were disposed of by the judgment, a copy of which I have placed, my lord. It's only downloaded from Indian Constitution website. I couldn't lay my hands on the certified copy of it. I have requested some friend of mine to.
So this WP Civil 12027 of 15 from Delhi High Court and transferred to the Honorable Supreme Court
At the instance of Union of India.
is part of this order.
Yes, Your Lordship may find them on the top of the.
The Federation. The Federation.
Numbers which are indicated.
I'll go through that, Lord, because
Because NMET, they may not have any control at all. But only thing is, state becomes a nominal agency to collect the NMET on behalf of
my
central government.
learned friend is representing the central government.
At request of learned AGA as well as learned ASG, relist on 15/3/20.
Right.
I represent third respondent now.
I'm the petitioner, my lord.
And respondent.
I appear for respondent 4.
Any party in person?
The Bar Council. Lord, I beg to appear for the association, Lord. Association of Advocates. Now, may I make one request, Lord, before your Lordships take up the matter on merits?
Yes.
Please, Lord, pleading application is pending. And if Lordships were to kindly allow the application, my Lord, I will collect the petition copy from the petitioner. I will file my response on behalf of the association, Lord.
All right.
Meeting was conveyed, plus Registrar General has conveyed the meeting, where my lords, the chairman of the Karnataka State Bar Council, my lords, the president of the association, and the representative from the Advocate General Office have attended the meeting, my lords. A deliberation has taken place relating to the building which my lords present in Karnataka State Bar Council is hosted. My lords, that my lords, proceedings, my lords, the Registrar General will be placed before the building committee, my lords, what the Registrar General has instructed me, my lords. He has asked my lords 2 weeks time, so that my lords further
will allow this application
yes,
for implementation.
yes, that it may be allowed.
Accepting the reasons stated in the application, IA number 1 of 22 filed by the Bar Association is hereby allowed. Applicant is permitted to be impleaded as additional respondent number 5. Full stop. Carry out amendment and file amendment first title by next date of hearing. Statement of objections, if any, to be filed by next date of hearing. Relist on
22
2 weeks other date. Learned AGA submits that meeting would be
Meeting has been conveyed and meeting has been attended by the chairman of the Karnataka State Bar Council and the president of the association,
right,
and the representative of the AG's office. Right. That proceedings of the meeting and the result outcome of the meeting, Registrar General will place before the building committee of the Honorable High Court.
Learned AGA submits that as submitted on 14/2/2022 before this court, a meeting of the representatives of the Bar Council, Bar Association, along with the state government on the administrative side has been convened. And the minutes of the meeting have been submitted. The reports and the minutes of the meeting have been submitted to this court.
It will be placed before the building committee.
Would be submitted
by the Registrar General.
Would be placed before the building committee by the Registrar General.
By the Registrar General to the committee.
By the Registrar General to the committee.
Please.
Submission of learned AGA is placed on record. Please. Relist on before this is previous one.
22-3.
Bless.
Number
17.
Here for the respondent number 8, my lord.
Number 17, I am for the petitioner, my lordship.
Yes.
Amendment carried out, my lordship. They have to file their objections.
Appear for the newly impleaded respondent number 8, my lord. I request for 2 weeks time, my lord, to file my statement of objections.
at request of the additional impleaded respondent, the Bangalore Electricity Supply Company Limited, relist after 3 weeks to enable them to file statement of objection. Date ಕೊಡಿ.
I appear for the petitioner, my lord. The state has to submit its survey report. Now the summer has set in, they may be asked to expedite the survey, my lord.
No, my lords, we have filed affidavit on the last occasion saying that, my lords, water is there in the lake. For that reason, we could not commence the survey. Now, present affidavit is filed by Tehsildar today, my lords, where, my lords, Tehsildar has fixed the date of survey as 16/3 and notified all the interested person, including, my lords, WOF board, which, my lords, they are claiming, my lords, they are the, as per the contention of the petitioner, that they are the encroachers, my lords. We will conduct the survey and place that report before, my lords. 16/3 is the, my lords, date, my lords, fixed for the survey. Notice is issued on 28/2/2022. Notice for the conducting the survey.
Survey has not been conducted.
Number 28/2 is the date of Miller's notice issued. 63 is the date Miller's which survey would Miller commence. We could not conduct the survey for the reason that lake was full with Miller's water. They could not enter the Miller's area there Miller's for the purpose of conducting the survey. There is a delay Miller's for that reason.
Informs that by notice dated 28th of February, the Tehsildar has issued notice for conducting the survey on 16/3/2022. The survey report would be submitted on the next date.
6 weeks, Millers, because 3 weeks, it is more than 400 acres of the land, Millers. It will take some time.
15 days. Let's give a date after 31st of March.
Great.
Much obliged, my lord.
Number 19.
But 19, my lord, I represent Karnataka State Pollution Control Board. Lord, in this case, my lord, I have not filed my objections, but I am ready to argue on merits, my lord, even otherwise, referring to my order itself. My lord permits me, my lord.
Who appear for petitioner? What is the matter?
Lord, this is a my lord, matter. The Karnataka State Pollution Control Board has withdrew the consent for the operation of hot mixing plant. On the ground, my lord, a committee headed by Deputy Commissioner inspected the place, and it is not a place, my lord, where hot mixing plant can be established. It comes under a zoning, my lord, of a reservoir area, backwater.
There is no statutory remedy against the order.
Lord, against this sort is not there, but my lord, subsequently we have passed a closure order, my lord. That is on 19 May 2021. We have filed a closure order. We have issued closure order against which, my lord, he has to file an appeal before the NGT.
NGT, National Grid.
This order is not an appeal before the NGT, my lord. But subsequently, we have issued a closure direction, closing the plant. That they have to challenge before the NGT, my lord. Under section 16 of the NGT Act.
It's not there.
So that he can comprehensively challenge all their.
Now, in view of the subsequent order, whether this order survives or not.
But this order, my lord, is challenged on different footing, my lord. We have withdrew this order here after following procedure, my lord. But the facts are remain same, my lord. He has to get over, my lord, the citing guidelines itself. May I take, my lord, page 88. Page 88.
No interest.
My lord is.
Revise.
Page 87, my lord, is the impugned order, annexure L.
Petitioner is not here, let it be taken in the revise.
Taken Monday, my lord, Monday.
Revise today itself.
Afternoon, my lord.
We cannot assure you like this.
Sorry. Then my lord's convenience, my lord, in time.
We'll take up in the revised list.
Please, my lord, please.
Number 20. Sumoto repetition.
8/2/2022. Order, my lords. On that, my lords, there is no, my lords, provision for implementation of the rules and penalty, my lords. For that, my lords, I just point out, my lords, from the order itself.
Is it not possible to prevent processions and all that? It's not possible. Even today, make the circle, palace grounds. I took 1 hour to come from Nyayagram.
Regulation, my lords, we have done it.
Something has to be done. No, I mean, what is the point otherwise?
No, why don't you mark a place for agitation? Somewhere in some park, somewhere, you put the
Freedom Park, old center.
Yes. Now, my lords,
and ensure that all these agitations are not taken on the road, and let them go there at that place and make the agitation there. Can't you do that?
yes, that, my lords, we can consider. Now, presently, a fresh order is passed, my lords, where it regulates the activity, including licensing power, etc.
Ban everything. Let them do whatever they want only in Freedom Park.
Yes, one is designated.
No, this is not something new. It's been happening from how many years? It's high time something is done. What is the point otherwise?
Now, what you have done with respect to implementation of the rules and the penalties?
Yes, sir. For that, my lords, very act itself provides for that. We could not point out, my lords, 100 and Police Act, Karnataka Police Act, my lords, 1963. Under that, my lords, this order is issued. Section 31(1)(o), my lords, is a power under the Karnataka Police Act. Commission has a power to issue this, my lords, order. My lords, 100 and
इसको restrain कर दे. Directed to they should not permit any agitation anywhere in the city.
Correct.
Except
in this Freedom Park.
And if any agitation is held in the vicinity of the city is found to be held, then action will be taken.
In this petition, petitioner is in this suo motu petition, the following reliefs are sought for. Extract money. Since there are several issues with regard to holding of processions and qua the rules, and whether the processions, protests, etc. can be held in accordance with law, having regard to the fact that the processions, protests, etc. have serious repercussions on the city as well as a cascading effect on the day-to-day activity in the entire city, including traffic, etc. Pending decision in this petition, we deem it just and appropriate to direct the state government to ensure that no protests, meetings, processions, etc. are held in the entire city of Bangalore except
By any group of persons,
by any group, political, non-political, etc. till except at the Freedom Park.
Any group or any political party.
Any political party, organization, etc. except in the park known as Freedom Park, Gandhinagar, Bangalore, in an organized manner and by ensuring the traffic in the city does not get adversely affected, especially during rush hours. Full stop. It is further directed that in case the any such disruption of the traffic or
any such activity is carried out,
the state government shall ensure that the same is immediately stopped and a report in that regard is submitted before this court. Correct, no, sir? No, not. Any such activity is carried out, the state government will ensure the same is further directed.
Remove it. Say that no such activity shall be permitted to be carried out, and in case any such activity is held, the appropriate action shall be taken, and the responsibility of the agencies meant for providing a proper traffic regulations shall be fixed and action taken in this regard shall be reported to the court.
That state government is directed to ensure this order is implemented forthwith at the earliest.
Implementation rules is already provided.
Right. Nele, on 8/2/2022, this court passed the following order. Not required. This court perused the e-gazetted rules and found that there is no provision made.
On the last, can you help me? AGA, on the basis of instructions informed that the implementation of the e-gazetted rules is already provided.
Section 103 of the KPID Act and 188 of IPC Millers, where Millers punishment action can be taken.
Say it again if you will not.
Section 103 of the Karnataka Police Act 1963 and Section 188 of IPC. And the jurisdictional inspector is the authority who has to take action under the rules.
And the jurisdictional the police inspector is the competent authority to
enforce
these rules and take appropriate action in case of violation of these rules.
Released first week of April.
Okay. Number 21.
Yes.
The reflection wherein writ of mandamus is sought for against the respondents, particularly against the respondents, providing proper sanitation and drainage facilities to the town of Channapatnam. The municipality was established about 50 years ago, and about 25 years ago it's been converted into city municipal council. That's of 50 years, Manoj.
You have filed rejoinder. You had asked time to file rejoinder affidavit.
I filed. Also filed an application to implead the Karnataka Urban Water Supply and Sewage Board.
Who appear for respondent? Not three.
I'm appearing for the second respondent.
Yes.
Kindly go to annexure R1 which I have produced along.
Whether the flow of sewage water into the lake has been stopped or not.
So far as sewage is concerned, it is not allowed into any river or tank.
We are not talking about the tank or river, we are talking about the lake.
Not even to the lake also, because it is still in the process of construction of the underground drainage, manhole, then septic tank.
What has been done?
Nothing has been done.
It has been done nearly.
Even according to their own objection statement of objection filed, they initiated the laying of drainage in the year 2005. Because of some technical reasons, they are unable to complete it. And even the septic sewage treatment plant has not been set up. there's no sewage.
STP has not been established.
It has been established, but only thing is it is yet to be commissioned by the Karnataka Urban Water Supply and Drainage Board.
The only
In fact-
identified, sorry.
You go on, sir.
The only identified the place, and in fact, even the Lordship kindly produced page 93 of the statement of objection, the states produced by them. The sewage treatment plant is sought to be set up between a lake and the river, my lord, which itself is illegal, cannot be permitted.
Where is the sewage going as on today?
So for underground drainage, connection has not yet been given.
Where is the sewage going?
As usual, it was, as was prevailing
As it was earlier.
earlier.
Where?
Work is in progress, and Urban Water Supply and Drainage Board has written letter to the government to release 106.5 crores of fund for the implementation, complete implementation of this
Urban
scheme.
water supply, they made an application.
We go to paragraph 2 and 3 of the statement of objection which are
Control Board. You carry out the survey inspection and submit the report as to what is the mode of treatment of sewage. Is there any treatment is being done to the sewage, and how it is being disposed of. Where it is going.
Work has to be done by respondent in 2 minutes. Survey has to be done by respondent in 2 minutes. State government.
What for you are here?
See, pollution is there or not, that's all. I didn't take action.
As per you, whether the water, this lake water and river water is being polluted by the sewer or not? Yeah. What? Huh? He doesn't understand anything. What you are doing?
I will get the
Where is Mr. Joshi? Huh?
Sir, this bold may be
4 of the statement of objection which I have filed. Paragraph 2, 3 and 4.
We have seen it.
In 2007,
We have seen it.
and the Karnataka Urban Water Supply
How the amount of 8 crore was released in favor of the contractor without completing the work?
work was carried on. At a later stage, it was found that the work was going on a very slow pace. Therefore, the contract was terminated and fresh proposal was submitted to the government.
No. Now you have submitted a project of 108 crores.
106.5 crores.
106.5 crores.
It is submitted by the Karnataka Urban Water Supply and Drainage Board.
And earlier, the project was sanctioned for 8 crores. And without getting the work completed, you release the amount in favor of the contractor.
Not the entire amount, some part of the amount was released by the
This is
Karnataka.
what you have written.
Kindly see,
And in all rupees 8 crore has been released to the contractor for the work executed.
Yes.
Not for the work completing.
Of course, he was found to be slowing down the work because of the escalation of the cost and all that. Then the urban water
The
supply
work was sanctioned for 8 crore only. That amount has been released without ensuring the work completion.
No, the initial sanction was for 30.1 crores.
Where you have written?
I have stated in paragraph 2 of the statement of objection. It is submitted that in 2007, administrative approval was granted by the government for laying underground drainage pipes, construction of manholes and provision for septic tank at the cost of 30.1 crores. In November 2007, after inviting tender from intending contractors, work of providing underground drainage connection.
Now for the same work, you have again submitted an estimate of 106 crores.
It is the
This is your conduct.
Urban Water Supply and Drainage Board has submitted the proposal to the government for releasing of the additional amount. Government is yet to react to the proposal sent by Urban Water Supply and Drainage Board. The moment the amount is released, the work will be given a speed.
We will restrain you from discharging the sewer in the lake and the river. Now you do whatever you feel like.
Yes, I understand.
Yeah.
So far as the municipality is concerned, it is not.
It is not our concern as to how you will discharge the sewer. We will only restrain you from discharging this in the river and the lake.
So far as the municipality is concerned, it is not discharging any sewage to the lake or the river. In fact, that has been made specifically clear.
You say
in the
that you are
statement
not
of objection.
discharging, we will record it and we will say that it will not be discharged. All right.
But what I submit before this honorable court is, unless and until this underground drainage work is completed, in fact, we have provided sufficient land for construction of.
We are not concerned. Looking to your conduct.
Then
We are not concerned. But we will not allow you to discharge the sewage in the river and lake.
municipality, as far as municipality is concerned, it has provided sufficient land for construction of STP, then a sewage treatment plant, and then other aspects of the matter. It has been provided and handed over to Karnataka Urban Water Supply and Drainage Board. Only thing that is required to be done is laying of underground drainage pipes, which has been stopped for the reason that the contractor did not complete the work on time.
Heard. Then a counsel for the petitioner as well as a counsel for the second and third respondent. This public investigation has been filed raising the serious issue of discharge of sewage in the lakes and river situated within and around the municipal limits of Channapatna. From the evidence made in the writ petition and after hearing the counsel for the petitioner and the counsel for the second and third respondent. Prima facie, we have found that no serious efforts are being made to get the provisions made for treatment of sewage before its discharge in the river or the lakes. The STP plant has not been made operational, and the underground sewer discharge system has not been made operational.
Has not been laid also.
Has not been laid, as is still the work has not been completed. Full stop. The respondents are responsible for not making proper efforts for the treatment of sewage before its discharge in the river and the lake in and around the municipal limits of Chinnappa.
Lake tank.
Tank. Full stop. We therefore direct that the respondent shall make the proper arrangement for treatment of sewage before its discharge in the river, tank or lakes, and for that we grant 4 weeks time to the respondents. No sewage shall be discharged untreated in the river, lake or tanks after period of 4 weeks. Give it.
7th April. Number 22.
क्या डेट दिया भाई?
7th April.
7th April. Number 22. Nagaraj Degde.
The last date of the government took time to get the decision before the cabinet. It was the direction issued.
Here for the respondent number 1.
In this, my lords, my first submission is that as on 4/9/2021 itself, my lords, as on 4th of September 2021 itself, my lords, we have communicated to respondent number 1 regarding the position, my lords. The financial difficulty being there, my lords, there are already, my lords, 123 such proposals that are pending before us, my lords, and the cost of all that would go around 2,000 to 3,000 crores, my lords. Considering that difficulty, my lords, in this particular overbridge that is being sought for, my lords, the TUV, that is Prime Vehicle Unit, is less than 1 lakh, my lord. In such situation, my lord, state has to incur the entire exchequer. Otherwise, state and the central government will share it by 50-50.
What decision has been taken by the cabinet?
Yes, my humble submission is the decision of the state has been communicated, my lords, that we are that proposal of first respondent has been that we are not in a position to accept that, and that communication, my lords, has been made to first respondent. And in that regard, my lords, I may have to file a objection and put that a week's time will be given, my lords. And
When the decision of the cabinet has been communicated, first respondent.
4/9/21 itself, my lords, has been communicated.
ऐसा इस order में तो नहीं है.
Yes, my lords, that I saw, my lords, on the 18/11 there is a submission made, my lords. I secured the record, my lords, on instruction and submitting that.
You appear for?
Respondent number 1, my lord.
Have you received the?
There is a communication by the state government on 4th of September 2021. However, in the proceedings on 18/11, it was submitted on behalf of the government that the proposal is pending with the state government. The same has to be considered.
No, you have received it. You tell us what you have done.
On 4th of September, they have sent a letter. In that letter, they say that there are 123 level crossings with more than 1 lakh TUVs pending state government's approval for sharing of cost. It is not financially prudent to take up the work of LC having less than 1 lakh TUV. More than railway engineering code stipulates state government involvement in construction of ROBs in lieu of LC gates is limited to such LC having more than 1 lakh TUV. State government is not in agreement with your proposal for construction on deposit term. In view of the foregoing, KRCL may take up the subject work from their own funds. But as per the policy, my lords, wherever the train vehicle unit.
It is between you and the state government to decide whether we are supposed to decide. What for you are arguing? Why, if you think that it is under the policy that they have to do it, they go and pursue them. Issue direction.
My lords, it is the petitioner, it is the lone petitioner who is before the court seeking for this railway road under bridge, my lords. So we have stated our position in the statement of objections. If I may invite my lord's kind attention to para 9, my lords.
Have you held any meeting with the state government after receiving this proposal?
You have to take instructions on that. There has been correspondence between the state government and the respondent number 1.
Statement of objections, para 22. Construction may not be required at all because of the distance and all that. Understand? We can't do, state government doesn't want to do. According to us, not required, we will not do.
Then how can we insist?
This has financial implications, my lords. For us, while executing the work, we'll have to factor in various aspects. And therefore, if the petitioner insists on having this, we'll have to abide by the extent policy, my lords. And the policy at present, in the present circumstances, does not permit the
respect of the same distance. They have provided railway overbridges. Similar at, like in this station, this area, same size, same dimensions. Have you provided railway overbridges at other places? If you have, then here also you have to provide.
No, my lord. So we are in the position of from manned level crossings.
Correct.
They are being.
Kindly see what you have said in para 22 of your statement of objections. LC 62 is located at railway kilometers 554 so and so.
Yes.
There is an existing road under bridge.
Yes.
Then you talk about the dimensions. Then you go on to say is during the period of closure, the detour can be used, therefore not required.
Yes,
but in respect, in relation to other area places, other intersections or wherever.
That is based.
That if you have done it, then you can't say it's not required here. No, you give the details where all it is done. What is the minimum width? What is the minimum distance required?
My lords, providing of these road overbridges is based on certain planning and based on technical expertise. The railways decide based on the requirement, and only when this train vehicle, wherever there are manned level crossings, if at all the situation warrants to provide this one, they will provide it. So
Where is the study done on so far as this level crossing is concerned?
As far as this level crossing, the census indicates that presently the.
Where is the study? Where is the survey? Where is the feasibility
On what
report?
basis you have come to conclusion that it is not required?
Not required.
We are not saying that it is not required. We are saying that it is feasible to be undertaken, but presently, may.
Para 22 last sentence may not be required at all.
We go what you say only. Without seeing, we can't say that. We have seen it. That is why we are saying that you have said that you're not required. Or what is the material on the basis of which you are saying that it is not required?
We have carried out a study, and that study is reflected in page number 15 of the statement of objection, annexure R1.
Communication.
Yes, madam.
R1 is a communication.
Communication, para number 2. As of now, the train vehicle units for this LC is 96,000 as per the census. Construction of ROB in lieu of the 11th crossing at 80 meters distance towards Roha is feasible at an approximate cost of around so and so, as per the earlier estimates, which may go up during the time year of execution due to escalation and other factors. KRCL can take up.
This is a reply. This is a reply to the state government letter dated 18/11/2019.
They have undertaken a study. They have looked at the feasibility of providing.
What is that?
That I will place it on record. There are some sketches and.
You have to justify now, sir. They are taking a stand. Let them justify.
But this is basic. Providing. Lords, this is a policy for this ROBs.
A decision has to be based on some material. No?
You are a public body.
Yes, my lord. Then, at the instance, then everybody will come forward seeking for a ROB at the place that they desire. That cannot be the.
That's right, but you need to point
Your
out.
decision has to be reasonable.
Yes, my lords.
That satisfaction you will have to give.
We are not saying that an ROB cannot be constructed. It is feasible to be constructed, but.
All right, but not to construct ROB should be based on some reasons.
We are saying that we will take it up on term deposit, a deposit term basis where the state government provides the land as well as the cost of the work. The state government is saying that we are not in a position to provide we cannot undertake.
So in no place without financial assistance from the state government and land assistance, you have constructed. In the remaining places, remaining level crossings,
Yes.
even if the state government, wherever state government has not provided financial and land assistance, you have not done it, is it?
My lords,
get instructions, which all places you have done, how you have done it, whether it is partly funded by you or partly funded by the state government. All those details we want.
May I just point to para number 9?
Only communication and your pleadings. We need material.
May I just point to para 9 of the statement of objection?
Okay. (50/50)
It is submitted in lieu of the railway board's operating policy. Matter cannot be prioritized ahead of the ahead of matters which, according to policy, have to be executed on priority. Further, the implementation of
Which is priority? This is least priority, according to you.
What happens is we execute projects relating to gold.
Give all those details. Which are the projects already executed? Which are the projects funded completely by the state government?
What is the criteria on what basis you take a decision to construct your own, and where you take a decision on 50/50 basis, or where you say that if the finance is provided and the land is provided by the state government that you construct? Is there any criteria for deciding this?
Para 11 has the.
We need material, not just a statement in the objections. We need material.
Place it.
The documents. Some material.
Some policy must be there.
The railway board's policy.
And they'll have to file rejoinder if they want. Learned Counsel for respondent number 1 seeks time to file additional statement of objections and additional documents, if any, in support of its defense. Learned AGA on instruction submits that the state government has already taken a decision not to provide any land or financial assistance to respondent number 1 to construct the railway overbridge at the subject location.
My lords, if land is not provided, then the railway cannot. Railway only provides technical.
That's what he said. He said, we already said we can't do anything. Is that the submission?
That may be.
I don't know. Yes, we have.
They are saying the government of Karnataka is not in agreement with your proposal for construction on deposit term. They take up the subject work from your own funds, my lords.
So it's only financial assistance.
If the railway were
only financial, is it?
Yes. If they were not to provide the land as well,
that's what he said. All right. Financial assistance in favor of the respondent number 1 to construct railway overbridge at Konkan Railway gate number LC62 at kilometer 554/190 near Hegde village, Kumta Taluk, Uttara Kannada district. Submission of learned AGA is placed on record. Learned Counsel for the petitioner seeks time to file rejoinder, if any, to the statement of objections. Relist April 1st. Produce material, additional material. We can't accept whatever you have said and close it. On the ground, it is not required.
I will file the policy and
7th April, one submission. I would file this letter also along with my statement of objection, Lord. Just to clarify, my Lord, the letter reads like this, my Lord. It says that Railway Engineering Code stipulates that the state's involvement in construction of ROB in lieu of LC gate is limited to such LC gates having more than 1 lakh TUVs. Therefore, Karnataka, government of Karnataka is not in agreement with your proposal for construction of ROB on deposit term basis, is what we have communicated.
Learned AGA submit. Instead of that, we'll say Learned AGA also seeks time to file statement of objections, placing on record the stand of the state government in response to the reliefs, in response to the claim put forth in the present petition.
Much.
Relist April 1st week.
7th April.
Right.
Number 23.
Correct.
In this case, I am for petitioner, my lords. My lords, this is a royalty matter where we have been asked to produce proof of payment of royalty by the vendors from whom we have buy jelly and etc. There are above 700 documents as such we need to produce, my lords. Kindly 2 weeks time maybe.
That may kindly recollect on the last occasion.
The last date we were dismissing the petition.
Yes, Lord.
Finally, 1 week.
Shows whether they have purchased it from the open market and whether those goods have already suffered royalty or not.
Yes.
That was the issue for which you had sought time.
Open market, Shivaji Nagar. Anyways,
What is the material to show that you have purchased the material from open market third party? The same has already suffered the royalty that you have to show. There is nothing on record to show. For that you had sought time.
Finally, request 1 week time.
No, sorry. Then we will dismiss. What? The writ petition has been filed seeking direction to respondent not to deduct any amount towards royalty while making payment of petitioner's RA bills raised in respect of work done by them pursuant to work order bearing, take it from the prayer work order number construction of roads with paver, blacks, such and such, and the work order such and such. It is further prayed that the direction be issued to refund the royalty amount collected from the petitioner in respect of the bill details of which are furnished in Annexure D and E, respectively. First off, the court-wide order dated 21st of February 2022 had granted time to the petitioner counsel to produce the documents to show that he has purchased the minerals from third party in open market and that same has already suffered the royalty. The counsel for the petitioner has not been able to produce any document to show that the said material was purchased from third party in open market and the royalty was already paid on this said material. First off, there is nothing on record to come to conclusion that the royalty was already paid on the material which was procured by the petitioner. In this view of the matter, we are of the considered view that the relief claimed in the given facts and circumstances of the petition cannot be granted. The writ petition being devoid of merit is dismissed.
24, Speaker Swami Jai, Petitioner Mela. In this case, the respondent is running a workshop and doing food farm, farming Mela in the place situated beside the school Mela. My Lord, may kindly look at page number 32 Mela. That activities are doing beside the school Mela.
The PIN?
Third respondent except page number 31 and 32 Mela. They are the photographs. Each shop is situated beside the school Mela.
Who are you?
He is one of the resident of that village Mela. Yeah. Many of the village people, including the petitioner, has submitted many of the representation to the respondents to take appropriate action against the respondent Mela.
We will direct for considering your representation. That is all.
That's all.
Because the school is not before us, children are not before us. Why you are bothered about it?
He is one of the resident of
Sorry.
village Mela.
You have said that it is in danger to the health and life of his school children. No school has come forward to say this. Why you are bothered?
He is one of the
This public interest litigation has been filed, seeking following relief. After considering submissions made by the counsel for the petitioner and going through the record, we are satisfied there is no material on record, that there is no material on record to show that there is any danger to the health and life of the school children or general public due to the activities undertaken by fifth respondent in the Ipana fork stall.
Photo is there. So instead of saying that material, we simply say representation can be considered.
The danger to the activity. Full stop. However, it is open for the petitioner to raise his grievance before the authorities concerned who have
already raised,
who have granted the license of the permission in favor of the fifth respondent to carry out the performing full stop. If learner counsel for the petitioner submits that he has already raised his grievance by way of a representation dated. Where is that representation? Which one you want?
Annexure B, C, D and E.
Give one detail of one which you want
Date
to
B
decide.
is 10/3/2021, my lord.
Eh?
10/3/2021.
After that also you have made so many.
It has been submitted.
Last one, give the detail of last one.
2/8/2020,
copy of which is annexed as annexure number E to the writ petition. However, the concerning respondent have not considered the same. Full stop. The writ petition as such, in the given fact and circumstances, is disposed of with observation that the representation of the petitioner dated 2/8/2021 shall be considered and decided by to whom you have made it.
That is made to Deputy Commissioner, my lord.
Respondent number
2 and 4.
Who is not a respondent, my lord?
My lord, he is not respondent.
He is not a respondent.
He has submitted to.
He is not a respondent.
Respondent number 2 and 4, my lord. He asked for annexure B and D, my lord. He is the local body. Therefore, he has submitted representation to respondent number 2 and 3, my lord. As for annexure D, my lord.
Chief Executive
C is given to R3. Annexure C is given to R3. He is not given to Deputy Commissioner, who is not a party. But state government is there, so we can always R1.
Annexure B and D are.
Who is the competent authority to grant permission? Deputy Commissioner?
No, my lord. Not Deputy.
Chief Executive Officer?
Correct. Chief Executive.
Charter.
Or Tahsildar. R2 or R3. Annexure C and D we can say. Sir.
Instead of C, say C and D, and consider and decided by second respondent, Chief Executive Officer.
And third, second and third. Either of them. We don't know. As on today, we don't know who will be the right person.
Chief Executive Officer, Jilla Panchayat, Hassan District, or the Tehsildar, Chandarapatna Taluk. In accordance with law and take appropriate decision expeditiously, stay within a period of 3 months from the date. Certified copy of the order along with copy of representation is placed before him.
25. I appear for the petitioner in serial number 25. May I request my lords to see the order dated 28/1/2022, my lord. Then it had come up for preliminary
Lord, in
hearing.
this case, statement of objections are ready, Lord. I am filing it today. The last may kindly have it next week, Lord. Any day.
Mr. S.
And
Mahendra
it may be called along.
informs that statement of objection is ready. He would be filing the same today in the registry itself after giving notice to other side.
Please. This may be called along with Lord. WP number.
Give a date after 10 days.
Lord, because one more PL is pending connected to this matter. This may be called along.
Not connected with
17262. Please.
It's not connected with any PA.
16th March.
Number 26.
I think the learned senior counsel is saying.
Appear for the petitioner.
No, they are not. Next time we will
Appearing for the petitioner in serial number 26, my lords. The grievance of the petitioner has already been addressed, my lords. And the playground has been brought to its original condition by the respondents, my lords.
Lord, Annexure R3, page 8, my lord. The photographs along with statement of objection.
got submission and close it. Learned counsel for the petitioner submits that as can be seen from annexures R1 to R3 filed along with the statement of objections, the grievances of the petitioners have been sufficiently addressed, and consequently the petition has been rendered infructuous. Full stop. Submission of learned counsel for the petitioner is placed on record. Petition disposed of as having become infructuous.
Please.
27.
I give the respondent number 1 in the matter.
Yes. What is the matter?
It's an appeal, my lord, against the Honorable Principal Secretary, my lord, dismissing my appeal, which was filed, my lord, against the award passed by the arbitrator, my lord. Not brief fact in the case, my lord, the appellant, my lord, had entered into a contract with the first respondent for construction of certain mess.
Who had filed the arbitration? Claimant?
I had.
Not claimant. Then claim was allowed?
Yes.
Thereafter, who filed the 34?
I filed the appeal under 34.
Appeal has been dismissed. Now you have filed 37. Yes, what is wrong in the order?
My lord, the arbitrator, my lord, has substituted his own views, my lord, in passing the award. My lord, parties substituted his own views, my lord, as such, my lord, the award suffers from illegalities. My lord, my submission would be that the parties have entered into the contract, wherein, my lord, the contract had to be completed within a specific time frame. And my lord, during the set period, my lord, if there was an increase in the minimum wages, which would be more than 10% of what was agreed upon, the appellant was, this particular appellant, my lord, was liable to compensate the respondent. I would, my lord, I would only take, my lord, to the award passed by the.
Doesn't seem to be anything.
Seriously, you tell us, is there anything wrong in the order passed under 34?
My lord, as far as two issues are concerned, my lord, there is some problem, my lord, because, my lord, as far as providing the calculation of minimum wages are concerned, my lord.
That has to be as per the prevailing rate.
Yes, my lord, as per the prevailing rate.
Yes.
That has not been done, my lord.
What has been done?
My lord, I would take my lord to the award, my lord.
What has been done as per the rate provided under the contract?
Yes, yes, my lord.
That cannot be done. Sorry.
And secondly, my lord,
Wages has been accepted and affirmed by the section 34.
Sorry, next.
second, my lord, the calculation, my lord, this particular contract, my lord, was executed at a place called Sambra, which is near Belgaum. My lord, that particular, the minimum wages, my lord, which is calculated for that particular area, comes under C category. As a result of which, my lord, there is a huge liability, my lord. There is an interpretation of the contract between the party itself, my lord, by the learned arbitrator, my lord, is wrong. And the Honorable City Civil Court, my lord, I am sorry to say this, my lord, absolutely, my lord, has just repeated whatever the arbitrator has said, without giving any reasons. I understand, my lord, the scope of review is very less.
Then?
But, my lord, yes, my lord, but nevertheless, my lord, may kindly see. My endeavor would be just to bring it to the notice.
Rate, how can we decide?
Correct.
We cannot.
Pure questions of fact.
That we cannot enter into. Sorry. The order. We'll pass the order. We do not find any information in the order.
Basically, my challenge on issue number 1, my lord. Rest of it, my lord, yes, I agree, my lord.
That is factual matters that we cannot enter into. What should be the rate and all that. That we cannot decide in 37.
In fact, what happened, my lord, it is like this. The minimum wages cannot be paid when there is no work done.
That also we cannot decide.
Second,
that is also factual.
As far as even interpretation, my lord, and substituting the terms, my lord. Those were not the terms which are agreed upon. Substituting of the view, my lord, will come under 2A.
28, R. Kutwal.
Thank you, my lords. My lords, I'm filing the translated copy of the key document pertaining to the 371J and that is in the vernacular language. I'll file the translated copy today. It may kindly be taken up on Monday.
And then on the request of counsel for the petitioner to enable her to file the translated copy of the documents.
My lord, one submission matter in this matter, my lord. There is the writ petition filed in WP number 3386 of 2022, my lord. And there was a specific order that the matter also be tagged with this, my lord. That has your lordship may kindly direct the registry, my lord. WP 3386. So, receipt number 28.
The counsel, the senior advocate,
Mr. P.P. Hegde.
P.P. Hegde informs that there is already a direction to tag this writ petition number
3386 of 2022.
3386 of 22.
Please.
Writ petition, office shall verify and list accordingly.
There's some urgency in the matter. We are sought for stay of certain appointments to be made in the Consumer Protection Act, my lord. Identical question came up before the division bench of the Mumbai High Court, my lord, where the proceeding, the concerned provision has been struck down. The Honorable Supreme Court has refused to grant stay. Therefore, my lord, the entire proceedings for appointment under the Consumer Protection Act becomes illegal, my lord. Therefore, there is grave urgency in the matter. May I humbly pray, my lord, to kindly accommodate on any shortest date possible, my lord.
Your lordship, I draw your lordship attention.
All right, we'll list a early date. Give me date.
Please.
Matter is of the bench before single judge.
Your lordship, I draw your lordship attention to
matter which you are referring to is before the London single judge.
My lord, the matter was before the single judge has already made over the my lord. Placed the matter before the Honorable Chief Justice, my lord, before the division, this division bench, my lords. On the ground that the similar matter is before my lord.
Interviews are going on, I think, the lordship.
Appointment has been made, your lordship. That is subject to result outcome of the present public interest litigation, your lordship. Your lordship, even though there is a specific direction of this honorable court, your lordship, the appointment, I kindly invite your lordship attention to my memo of additional documents, your lordship. The order of this honorable court has not been referred in the list, your lordship.
Next week on date.
We'll see next time.
17.
Next week, an urgency.
Yes, next
10th.
10 March.
Please, grateful, my lords.
29.
Pertaining to this matter, the central government has filed a transfer petition, my lords, and memo has already been filed before your lordships. Yesterday also I verified, my lords. In fact, I am ahead of respondent number 16.
General counsel for the petitioner informs that the transfer petition preferred by the Union of India before the Apex Court on his request cases that
24 5. 30.
May I please? I appear for the petitioner's counsel.
yes.
But may kindly recollect the matter relates to promoting development corporations.
We will have it again after lunch. The bench is not there available.
In the meantime, may I make one submission? There was there's an impleading application that was filed by the learned counsel for the petitioner, proposing to bring on record several respondents. I've been instructed.
I have effected personal surveys along with the.
Consider next day.
Very good.
No, the IA may be allowed so that I'll file an amended cost type.
Give a date.
Early date may kindly be given.
Yes.
1/4.
Yes.
Number 31.
My lords, I am for the respond number 6. As per the direction of this honorable court, we have carried out the direction by issuing the show cause notice to the concerned constructions, my lord.
This is an application IL. This is the IA for implement. All right.
Local authority has passed an
But what is the date? Next date fixed? Is there any date?
No, the date was given for today.
No, it has come under application.
No, your lordship's order dated 20/12/2021 has directed the matter to be listed today. In the meantime, there was a direction.
The applications have come, that's why it's listed.
Case is not listed, only application has come.
No, that's my application.
We'll give a date. We'll give a date. The IA1 of 2022 is taken on record. The petitioner may file an objection within 2 weeks to the application for impleadment. Give a date after 2 weeks. It will be considered on the next date. Passover.
17th.
Passover matter, number 1.
Once again, once again.
Mr. Srinidhi,
My lords.
you seek instruction
Yes, ma'am.
on this TVCC report.
Yes. In fact, my lords, I sought instructions.
Give copy of
I
the.
have the copy. He's given me a copy.
Yes.
Lords, it appears that
His contention is that in spite of this report, the contract has been awarded to L2.
Yes.
Which is causing a loss of rupees for 61 lakh rupees.
Yes. I'll answer.
Yes.
According to us, my lords, there is no.
Srinidhi,
Yes, my lord.
Mr. Srinidhi, Counsel, advocate is present in the court. He has been handed over the copy of the writ petition on behalf of respondent number 2.
2 and 3.
2, 3 and 4.
2, 3 and 4. He may seek instructions on the issue raised in the writ petition.
Problem.
Give a date.
17 March.
Yes.
19. Jitendra MS.
He didn't come. First round, he didn't come.
Then dismiss it.
For non-prosecution, sir.
The list of cases is being revised. No one has put an appearance on behalf of the petitioner to press this writ petition. Writ petition has been filed seeking following relief. The counsel for the writ petition default as well as for want of prosecution, interim order finished and discharged.